Hey, Jess, it's Friday. So you may have recently heard about the so-called Blurred Lines trial, in which Marvin Gaye's estate took to court both Pharrell and Robin Thicke because they thought that the duo's 2013 hit Blurred Lines was way too much the same thing as Marvin Gaye's famous hit Gotta Give It Up. And, well, yeah, it kind of was. In fact, I put a link to a comparison video down in the thingy. Now, just to be clear, there are two types of copyright when it comes to recording. There is the recording itself, and then there's the copyright for the composition. And it's the composition copyright that's in question in this case. Now, assuming that you heard about the trial, you probably also heard that the 8-person California jury sided with the Marvin Gaye estate and awarded them $7.4 million. To get to that figure, consider this. The jury basically said, okay, $4 million in copyright damages. And then on top of that, both Pharrell and Robin Thicke have to kick in another $1.8 million because of the profits that they made. And it actually could have been a lot worse. The jury considered that this wasn't willful. In other words, they said, nah, they didn't mean to do it. Also, understand this, that the single Blurred Lines has been estimated to have grossed around $17 million. Now, that money goes to a handful of people. Aside from Thicke and Pharrell, we're talking about T.I., who was also featured on the track, as well as the record labels. Because the way that the earnings were split up or made public, we're able to determine that both Thicke and Pharrell got around $5 million each. And on top of that, they got around $860,000 just for producing the song Blurred Lines. So if you take what they earned and then minus what they now owe, they still walk away with a decent profit. It's not like Robin Thicke is knocking on his dad Alan's door and asking for some of that Las Vegas commercial money. And most musicians and artists don't carry insurance for this kind of thing. If they did, it would be like incredibly expensive. And by the way, to help get to that verdict, the jury asked Robin Thicke to perform both songs there in the courtroom on a keyboard. Could you imagine saying to someone, yeah, I saw Robin Thicke in concert. It was an intimate performance. It was, I got front row seats to that. Although, if you think about it, it still would be trumped by anyone who was at the VMA performance with Miley Cyrus grinding on that foam finger. Now, as it turns out, I happen to know pretty well one of the lawyers that represented the Marvin Gaye estate in this case. In fact, his son plays music with me on a regular basis, so I cannot wait to discuss this with him in whatever capacity the law allows him to. Now, some people are afraid that this is going to somehow stifle creativity, that artists are now going to be nervous every time their new single comes out, that they're going to get sued. But that's really not going to be the case. This is not something that is new. In fact, people have been going to court over these kind of things for years and years and years. And there are a lot of songs that just sound like other songs, both intended and unintended. But look, if you're going to sample someone else's song for your own song, be a little more careful and understand exactly how popular the lick is that you're going to steal. I'm talking to you, Vanilla Ice. However, for the short term, I'm sure it's going to start making some people nervous. As soon as this whole Blurred Lines trial started to heat up, it didn't take very long for Sam Smith to start dishing out dough to Tom Petty. Anyway, that's all I got for this week. So I hope you guys are doing well, and Jess, I will see you on Monday.